You're listening to Sound Side. I'm Libby Dankman. Civil rights groups are now scrambling to get ahead of a looming change to the status of babies born to immigrant parents without permanent legal status. There are 27 days until the Trump administration's restrictions on birthright citizenship are set to take effect in a majority of states across the country. That's because the Supreme Court on Friday limited the ability of federal judges to issue nationwide injunctions, blocking the actions of a president. As it stands now, starting later next month, babies born to immigrant parents who are undocumented or on visas in states like Idaho would not be U.S. citizens, while babies born in Washington would have U.S. citizenship. Washington was one of several states challenging President Trump's Day 1 executive order limiting birthright citizenship, but the Supreme Court's ruling has even wider implications for the power of the judicial branch to rein in the executive. And our state's attorney general joins me now with more. Nick Brown, welcome back to the show. Thanks for being here.
Thank you for having me. Appreciate it.
So I want to get to the status of Washington's lawsuit over birthright citizenship in a minute. But first, you called the court's decision disappointing on Friday. Can you share your general reaction to the ruling limiting nationwide injunctions?
Yeah, it was incredibly disappointing to read the Supreme Court's decision last week. My first impression was that the order would be more sweeping than I actually think it is, however. So on the one hand, the court did significantly limit the ability of individuals and states to get nationwide injunctions, which is really disappointing in this particular issue of birthright citizenship and what it means to be an American in this country. On the other hand, it still provided many avenues to get nationwide relief, including through lawsuits brought by the states. And I think what we'll ultimately see in this case is that as soon as today, perhaps, another nationwide injunction put into effect through some of the class actions that we're seeing brought already by parties across the country.
So you're seeing an avenue where these class actions, which again have already started to be filed, will move, in your opinion, just as quickly as a lawsuit from the Attorney General's office, for example, because one of the concerns initially after the ruling was that the class actions have a higher bar to qualify for, a class status, things like that. You
Sure.
think that these things could move quickly?
Well, let me say a few different things. I mean, one, the Supreme Court did not bar nationwide injunctions. They've certainly raised the bar to get a nationwide injunction, but they didn't explicitly prohibit nationwide injunctions, including by lawsuits brought by state attorney generals. In this particular case, one of the advantages, if you will, of the executive order that the president issues is that it explicitly defines, who and who does not qualify for citizenship under their unconstitutional definition of it. But because the order lays out very specific parameters, it makes it much, much easier, in this case at least, to define what a class of plaintiffs could be. And so, immediately on Friday last week, we saw two class actions brought. One has a hearing today in Maryland that may be going on as we speak. I would predict that in that case or the subsequent one that we'll see another nationwide injunction put into effect, because the executive order issued by the president is so explicit and it's really easy to define a class. That'll be much more difficult in future cases. As you know, class action lawsuits are incredibly burdensome. And I think the end result of the court's decision last week will be it'll be much, much harder in future cases for people to have their constitutional rights protected. And that is going to have a tremendous effect on a whole host of issues. And it's going to require people with the means and the money to get more lawyers, to bring more class actions. And I think that's going to be really, really limiting on people's ability to defend their constitutional rights. And it's going to have really wide ramifications for a whole class of people.
So the Supreme Court didn't rule on the actual constitutional question of birthright citizenship in the 14th Amendment. In this ruling, it had a procedural route that it took on the power of judges. What's the status of Washington State's lawsuit, your lawsuit over birthright citizenship? There was the injunction issued in February. Where does your case stand now? Is it still going forward?
Yes. So after we, prevailed on the preliminary injunction in the district court, we, of course, were dealing with the Supreme Court's procedural matters around the scope of nationwide injunctions, but our case continued to proceed in the Ninth Circuit. And so we fully briefed and argued that case in the Ninth Circuit just a few weeks ago. The Ninth Circuit paused that decision as the Supreme Court was making their decision on this issue. But immediately following the court's ruling last Friday, the Ninth Circuit issued an order to the parties in our case to further brief the impact of the Supreme Court's ruling. And so we will be briefing that in the next few days, and the government as well. Because importantly in our case, Judge Kuhnauer did decide nationwide relief was appropriate because of the sort of impracticality of states independently trying to administer the impacts of the executive order. So the Ninth Circuit could decide on its own, or it could send it back to the district court for further development of the record. From our perspective, the administration has never explained and never really even attempted to explain how this will proceed, where Washington, if you're born in Washington, you could be a citizen, but if you're born in Idaho, one of the many states that did not join our lawsuit, that you wouldn't be a citizen, and how that would be effectively administered, because states rely on determinations of citizenship for so many different programs that we administer. When you're born and you get a social security number, every state in the country, for example, uses that to determine healthcare benefits, education benefits, et cetera. And the idea that, you could be born in Washington and move or leave and go to Idaho and maybe your citizenship changes, or if you're a pregnant person in Spokane and you're traveling in Idaho for the day and your child is born over there, that they wouldn't be a citizen. It's really ultimately absurd result. And I think the Department of Justice and the administration is going to have to work really hard to explain to the district court here in Washington how such a system would work. So, ultimately we'll be back perhaps in the district court, or this might be just decided in the Ninth Circuit. But for me, what's really important from the Supreme Court's ruling is it shows how important it was for Washington to be part of this case, because but for our participation in the lawsuit, your citizenship is going to be, very vulnerable, like it is in Idaho or Montana or all these other states whose attorney generals didn't step up to the plate and join the case.
Does the ruling on judicial injunctions for the district courts change your approach challenging any other executive orders from the Trump administration?
No, not immediately. We're obviously going to have to be very exacting in our approach moving forward, but frankly, we've been that way from the beginning. And, we, the state of Washington, we've joined or led now 23 total lawsuits against the Trump administration in the last 5.5 months. But only in a very few of them have we actually sought and received nationwide injunctions. For example, in the vast majority of our cases, protecting funding to Washingtonians and Washington institutions, we have not sought nationwide injunctions. And so, for example, in our lawsuit challenging the illegal cuts to the National Institute of Health, we did not seek a nationwide injunction nor receive a nationwide injunction, which means those states that did not participate, every Republican-led state, did not get the benefits of our relief. And so we'll continue to be very cautious in how we approach these, and certainly the Supreme Court's decision will have a big impact on every party that's going before the courts moving forward. But that's true for Washington. That's true for every entity that might have sought and received nationwide injunctions moving forward. But we've always been very judicious in our approach.
I guess timeliness is a big issue on some of these cases and maybe not as much on others. I want to get your take on what Justice Brett Kavanaugh wrote in a concurring opinion when the ruling was released. He said that the Supreme Court will still provide a check on the president, even on a short turnaround, using the emergency docket. And basically, we've just seen the power of the judiciary centralized from 700 district judges to the SCOTUS to the Supreme Court. What's your take on that? Is that sufficient to provide relief?
Well, part of me laughs because what evidence is there of that? What has the Supreme Court done truly to put any check on this precedent? Time and time again, they have expanded presidential authority, executive power, and more often than not, that is abiding by President Trump's definition of power and the expanse of power. And so I think there's very little evidence that the Supreme Court is putting a check on this president. That's going to have a lasting impact well beyond President Trump. And this is why I think people need to be very cautious when they celebrate decisions because it benefits their own political interest or policy interest, because what is good for the goose is good for the gander. And so what we've now seen is a real expansion of presidential power and a limitation on the court's ability to check the president or any future president. And there is language in that opinion that I think should be very chilling for everyone in America, because, there's some language suggesting that even when the president does something illegal, the courts may not have a remedy to oppose that. And so, I think it's very concerning, not only in the short term, not only for the erosion of, foundational issues like what it means to be a citizen, but for opinions that are going to come down for years and years in the future, what this means for the balance of power in America. And it's a real, in my view, step back from what the founders intended, three co-equal branches of government, each providing checks on each other. Presidential power has expanded extremely in factors by this current iteration of the Supreme Court.
And I suppose that's how you would respond to the ruling from Justice Amy Coney Barrett, who wrote for the majority, saying basically these nationwide injunctions are what's getting out of control, that they've exploded in the last 10 years, and this is not something that had precedent. If you're subscribed to the originalist view of how the legal doctrine should be interpreted, you would say basically that you think that the executive has expanded power, and that these injunctions were important to provide a check on that.
Yeah, well, let me say a few things. One, I think, the concern around the expansion of nationwide injunctions is not a conservative or liberal viewpoint. I think people from all across the spectrum have somewhat agreed on the idea that we need to provide some limiting factors around the use of nationwide injunctions. And so there have been presidents of both parties who have complained about nationwide injunctions. There have been lawyers and judges of sort of all kinds of political and philosophical spectrums who have sought to limit the use of nationwide injunctions. And in my view, that's appropriate. So I'm not opposed to nationwide injunctions, just in theory, but I do think we need to be careful about the impact on constitutional rights and, how harder it's going to be to protect constitutional rights moving forward. But undoubtedly, the founders would never have envisioned the expansive view of executive authority that the Supreme Court and time again has supported in recent years, from its own presidential immunity on criminal issues to a host of other issues. The president simply has much more authority than ever before. And the reason that we've seen so many injunctions in the last 5 months is because this president has used executive authority like never before, and has done so with blatant disregard to the Constitution and for the separation of powers. Congress currently has no interest in providing any checks on the president, and the courts have really sort of, I think, doubled down on that idea that the president has this expansive power. And that is why we have seen so many judges of all political stripes. Trump appointed judges, Biden appointed judges, here in our case on birthright citizenship, a Reagan appointed judge, all saying that the president is acting illegally. And that is why we have seen such an explosion of nationwide injunctions, or injunctions that aren't nationwide, but that are limiting the president's actions. And, I'm really proud to be part of that opposition right now, because I think we all need to be concerned about the impact of rule of law, regardless of our own political views or policy perspectives. We need to make sure that every president and any president is following the law, and that's just not what we've seen from President Trump.
Any final thoughts before I let you go? Washington State Attorney General Nick Brown, on next steps here, or what people should know about where Washington State fits in all of this?
Well, there were 22 states in the District of Columbia that participated in the challenge to the birthright citizenship executive order. And those are the states that continue to defend what it means to be an American in this country. And I think on this particular issue, we will ultimately prevail on the substantive fight to opposing the executive order. And right now, we're really concerned about the long-term impacts of this initial ruling. But I think when the ruling ultimately gets to the court and to decide whether or not the Constitution has meant what we've said it's meant for the last 157 years, I think Washington will prevail, and I'm really happy to file the first lawsuit in this case.
Mr. Attorney General, thanks for your time today.
I appreciate it. Thanks, Libby.
Thanks for listening to Soundside. And hey, this show is only possible because listeners support us. If you are able to give right now, check out the show notes for a link to donate. And don't forget, you can listen live on KUOW 94.9 FM Seattle at noon and 8 p.m., Monday through Thursday, or anytime online at KUOW.org.